All right, I think the number is starting to slow down in terms of people joining. Oh, nope, there it goes. Okay. Well, let's get this going. Welcome everybody to Expanding Professional Licensure Responsibilities. What the Education Department's proposed changes mean for your institution. This presentation is being recorded and resources will be available after the event, but also we have posted, thanks to Chris and Nan providing them beforehand, these slides that you can access now and go along with the presentation. You can submit questions, and please do, through the Q&A option. We will answer questions at the end of the presentation. So please don't think your question is being ignored. And any questions that we do not get to during the presentation, Chris and Nan are very good at responding to those questions afterward, and we post those as well. And then, of course, at the end, if you would please be so kind to complete the survey that helps us in our future webinars. And I will hand it over to Nan Kauke to introduce herself.
Thank you, Leah. Hi, everyone. Prior to starting higher education licensure pros with Chris in the fall of 2020, I first met Chris when I worked at Capella University from 2010 to 2020. I first worked at Capella University in the role of a specialized accreditation specialist, very special, and worked across schools helping them gain specialized accreditation. Then I worked exclusively in the School of Counseling, really in program operations across many different areas like admissions, faculty advising, data analysis, curriculum development, helping them continue to meet quality assurance standards. Prior to that, I worked at the University of Minnesota, mostly in this like 13 years in the School of Social Work there. I helped them start up their MSW program and several statewide training programs in child welfare and foster care. So I also got my PhD from the University of Minnesota. So that's a little about me, and I'm going to pass it over to Chris now for his introduction.
Great. Hello, everyone. My name is Chris Mall. I have been working in professional licensure related issues in higher education for well over a decade. As Nan mentioned, much of my time was spent working for Capella University and then later Strayer University when those two joined forces a few years ago, really managing their compliance efforts around professional licensure. So I got to lead a team there and we dug into that research of the licensure requirements across all states and territories for all of the various programs offered. I got to work directly with many different state licensing boards over the years, advocating on behalf of our programs in the institution, as well as helping support individual students and graduates with their licensure efforts. And I got to work directly with our students and our graduates, which really was my most favorite part of that role, as being able to engage with the students and understand, their goals around licensure, what they wanted to do out in their community and their profession. So that's a little about me. As Nan also mentioned, we started Higher Education Licensure Pros in 2020. We saw a need in particular for those smaller to mid-sized institutions that were really struggling to comply with the current Department of Education and SARA policy licensure disclosure requirements. And so we've been working with institutions really of all sizes for the past few years and helping them dig into that research, set up their compliance processes, and again, support those compliance efforts in general related to professional licensure. So today, though, we are here to talk about those proposed Department of Education regulations that came out last month. Just want to kind of set the floor here, set your expectations for what we're going to do today. I wanted to say, first off, my goal in today is just to make sure everyone on the call is aware of what these proposed changes are and what the potential impacts could be to your institution. So we're not going to have concrete answers today because these are proposed regulations, and we really don't have much insight into how the department would interpret these proposed regulations should they move forward into a final version in the state that they are. So my goal is to make you aware, help you maybe plan for some of these things if they do come to fruition. And then we will have time for your questions at the end of today. So I know we've got an hour and a half scheduled. I plan to have plenty of time left over after I talk for you all to get your questions in. So as Leah said, please submit those via the Q&A throughout the presentation, and we'll make sure to address all of those that we can at the end here. Also, before I move on from this slide, you'll see my note at the bottom here, very important one. While I am an attorney, this is not legal advice that I'm giving you today. Really, I'm providing the information, and anything you do around licensure compliance, you should be getting some buy-in or weigh-in from legal counsel as far as those risks to your institution, and making sure that you have a plan that's going to best support your institution and your needs. All right, so let's jump right into it here. Department of Education's proposed regulations. So there are multiple parts to this, and I have it broken down, kind of different slides for each of these subparts related to licensure. But I wanted to start out first with what I think is the biggest impact, potential impact for this proposed change. So this is around a new responsibility for institutions in the program participation agreement, which is kind of that master agreement that every institution has to sign in order to participate in the Title IV program. So there's nothing about licensure that exists in the PPA today. Again, this would be a brand new requirement related to licensure in the PPA. So the PPA itself, every institution has to sign that, agreeing to those certain terms and conditions that are listed in the PPA upon that initial approval for Title IV. And then you have to do it again every time that your institution is up for that recertification process for Title IV. That could be as long as 6 years, depending on the cycle, or it could be an annual thing. Again, lots of variables go into when an institution needs to re-sign or sign again that PPA. But the bottom line is it will be in the PPA for everyone if this proposed regulation moves forward as is from the Department of Education. And so specifically with this section, I did just want to note that licensure is one small component of it, but a very important component. So there are a few other things related to the PPA, and I'm sure many of you on the line today are well aware of these related to accreditation and related to state authorization. I'm not going to be speaking to those today. We're just focused on the licensure piece, but I do encourage you all to make sure you're aware of what these other potential new requirements are. In particular, the state authorization piece I know is a pretty big one, and Sarah, the State Authorization Reciprocity Agreement, has been putting out a lot of information about that. So please check that out if you haven't already. Okay, I'm going to dig in now to the specific licensure related proposal in the new PPA certification responsibility. So I know it's not always fun to look at the language itself in a regulation, but it's very important just so we understand what the department has actually proposed here. And then I'll dissect this a little bit for each of these. So you can see on the screen now, here is the proposed new section that the Department of Education has put forward. So I am going to read it, at least in part here. In each state in which the institution is located or in which students are located, and as determined at the time of initial enrollment in accordance with that other subsection, the institution must determine that each program eligible for Title IV HEA funds satisfies the applicable educational prerequisites for professional licensure or certification requirements in that state, so that a student who completes the program and seeks employment qualifies to take any licensure or certification exam that is needed for the student to practice or find employment in an occupation. It's definitely a mouthful, right? So let's break this down a little bit. What are each of these new phrases in this section trying to tell us that the department is thinking? So first I wanted to start with, they removed ensure. Some of you might be asking, what does that mean? Well, if you were following along with the negotiated rulemaking sessions that were happening last year, which is what this language has come out of, right? So there was a negotiated rulemaking session that was covering multiple issues, and one of them was this certification requirement, which included this new PPA certification language. So during negotiated rulemaking, the department put forward proposed language and it included ensure. So originally the department was thinking, we want institutions to ensure that their programs meet the educational requirements everywhere that their students are located. During negotiated rulemaking, several negotiators brought up that this word ensure is very problematic for a number of reasons, right? So typically, institutions are not ensuring any particular kind of career or any other outcome related to a degree because there are just too many variables that are going on with particular students, and what their situation is. And then in addition, for licensure in particular, there are things beyond those educational requirements that someone needs to have in order to qualify for a license. So again, it's really hard to ensure a particular kind of outcome because of these variables that really are on an individual basis for folks. So we don't have ensure, which I think is a good thing. We do have this language that institutions must determine that their programs satisfy the educational prerequisites. Okay, what do they mean by determine? What do they mean by satisfy? Well, the department has not put forward definitions for either of these terms in their proposed regulations, and it does not exist in any of the current regulation that would be applicable to these sections. So my thought is, what's the plain meaning of the word, right? We can look at different sources for that. I chose to look at what's in the Oxford English Dictionary. What does it mean to determine? What does it mean to satisfy? So you can see here the definitions from the Oxford English Dictionary, which maybe give us a picture, but not exactly, right? It doesn't really give us that concrete idea of what kind of evidence might be needed to say that the program satisfies the requirements, or how do you determine it, right? Is it something that you have to have an external kind of group or authority, such as the licensing board in this case, help you determine, or is it something that the institution will be deciding or establishing on its own that it satisfies? So I just wanted to again highlight this important evidence piece that is a big unknown. If there would need to be some sort of documentation from licensing boards that programs satisfy those educational prerequisites, that could be a big problem because it simply is not very easy to get today, and in some cases is impossible to get today. Licensing boards are just not set up to review or approve out-of-state programs typically. So they don't have a mechanism to offer you some sort of letter of approval or some sort of document that's supporting, yes, your program satisfies our education requirements. It doesn't exist today. So this could be a problem depending on, again, what the department's expectations would be and exactly what they mean by each institution must determine that a program satisfies. So moving on through this new proposed section here, I wanted to highlight a couple other parts. Next one is around student location or location of the institution. So we saw in the proposed language that it is tied to the location of the institution or location of prospective students at the time of initial enrollment. So a couple of points on this. First, student location is still being left up to each institution to decide, which is what exists today under the current Department of Education regulations. So every institution gets to set up and determine their own student location policy, which must be applied consistently across their students. So that piece isn't changing. What has changed here with these proposed regulations is around the language that they're using. So in the current Department of Education requirements, they talk about prior to the student's enrollment in a program. And with this proposal, they're talking about determined at the time of initial enrollment. So we have a little bit of a variation here, which could mean nothing in the grand scheme of things, or it could have a big impact on when institutions are actually setting that prospective student's location, right? So it's going to be connected back to when does the institution consider that time of enrollment? And then we have this insertion of initial enrollment, right? So when does initial enrollment into that licensure program happen? It could be at the time that the student's applying to the institution, or it could be something at a later date. If you think about examples for undergraduate programs where students often are not declaring their major until after they've been admitted into the institution and, possibly had an undeclared major for a period of time and then get admitted to the program. So again, potential new variable here with the timing of this, which factors into exactly how and when a student's location is being determined. Just a side note here, both of these sections though, the current one and this proposed one, do refer back to an existing student location policy in 34 CFR 600.9. And because of that, I feel like the department may not be trying to make a leap or trying to make big changes in what it means for enrollment. But again, we will see. It's not known at this point exactly how this will play out and how the department will interpret this language if it moves forward as is. Final thought that I have on this new proposed PPA certification section is around the language that they've included related to exams, right? So the department is language is indicating those educational prerequisites such that a student can qualify to take the licensure or certification examinations. This is new. In the existing regulations, there's not a reference to qualifying for examinations. And so it is interesting that they've inserted this in here. However, I think the intent of the department is still the same, that they're really concerned about, does your program satisfy those academic or educational prerequisites that would be required to earn a license? One reason I say that is because of the discussion that took place during negotiated rulemaking. There were several negotiators, including those from the department, who were really focused on that idea of, okay, does the program meet all of the requirements someone needs to qualify for a license? If it's not that, if their intent is anything different or could be different, the examination piece does bring up some interesting questions, because there are certain license types that don't require applicants to pass an exam in order to qualify for a license. There are other license types where any person can go and register for the exam, no matter what your educational background is. And then in order to be licensed, you have to have passed an exam plus the education requirements. So those are kind of instances where the exam can happen first before someone would do a degree program, or potentially never even do the degree program. And then there's another, kind of bucket of examples here where particular programs can help qualify a graduate or student to sit for an exam after a certain number of credits. A good example of this would be an accounting type program. So to qualify for a CPA type license, generally states and territories require 120 semester credits that are in specific course areas. But to qualify for the license, you need to have 150 semester credits. So someone could complete a bachelor's level program with 120 semester credits, qualify to sit for that exam as a CPA, but they wouldn't yet be qualified to actually earn the license until they've earned those additional 30 credits that most states are looking for to be the 150. So again, just some examples, things to point out. We don't know what the department is actually going to do, how they would actually interpret this, and if this insertion of the examination connection is going to be relevant or not. So, all right, I'm going to move on now from that new proposed PPA certification requirement and jump into some of the changes that the department has proposed around the existing public disclosures and licensure disclosures in general. So you'll see on the screen here, again, I've captured the language directly from the department's proposal around the licensure disclosures. So this would be a change to the existing public disclosure requirement. And I'm just going to point out the highlighted section here where the department is indicating institutions would need to provide a list of all states where the institution's aware that the program does and does not meet the requirements. And again, the requirements are these educational requirements for a specific license or certification. So some of you might be saying, well, that sounds like what we should be doing today, right? It's very close, but there are some changes, okay? So first, I want to point out that it says meets and does not meet. There's no reference to this no determination made or not determined categorization of states. In the existing regulation, it does say that institutions can categorize a state or territory in one of these three buckets: meets, does not meet, or no determination made. This has offered flexibility, obviously, for institutions to be able to use that no determination made or not determined category for various reasons, right? Maybe an institution was trying to engage in the research to understand what the other state requirements were. And so they have those listed in no determination made until they're able to complete that research and compare their programs. Or in other instances, an institution could have decided, you know, we really aren't enrolling anyone from any of these states, so we're going to have them in this no determination made category. And then if we get questions from prospective students, you know, we will engage in the research and try to make that determination at a later point. So that no determination made option would be going away under the existing regulation. Something that is important to note here, though, is that the institution may have kind of a similar option or a similar approach to this because of the language that the Department of Ed has used in this proposed regulation. Is the institution aware of where it meets or does not meet, right? So I'm actually going to go back one slide here if I can. Sorry, bear with me. Here we go. So I don't think I emphasized this originally, but I will again. So a list of all states where the institution is aware that the program does and does not meet such requirements. So I think this idea of what does that mean to be aware, right? So some of your institutions might be currently or have already over the past few years engaging in this research and comparison work where you or your subject matter experts are really digging into what are those educational requirements for a license across the whole country, and then aligning your program to see if it meets those educational requirements. So I would imagine an institution that has been taking those steps would be aware if your program meets or doesn't meet the requirements. So you would need to be making this public disclosure under the new proposed regulation. However, if you're an institution that hasn't really dug into all states and territories yet to make that determination, are you aware of if your program meets or doesn't meet? That's a great question. Again, this is something that the department has not defined in their proposed regulations. There wasn't a lot of commentary around really any of this, truly, during negotiated rulemaking. But for this particular public disclosure section, there really wasn't much commentary. However, the negotiator for Department of Education did make a brief comment at one point that, you know, institutions are going to have to know where their program meets or doesn't meet requirements under the new PPA certification requirement, right? So you can only enroll students into a Title IV program if you can certify on the PPA that your program meets those educational prerequisites for a license or certification where the student is located or where your institution is located. So the negotiator said, well, because institutions have to know that anyway to enroll them, then they should be aware of where their program meets or doesn't meet. I think that's true, but it also doesn't really capture the full picture or the full nuance, right? So this current public disclosure is for all 59 US states and territories. This proposed disclosure, it's not specified if it really is for all 59 states and territories. It's this language, is the institution aware? I think that's a wild card. So there could be some movement here with what your institution is required to do around the public disclosures. Maybe it's not all 59 states and territories anymore. My opinion is that it's the department's intent that it is, but I don't think their language they're proposing here makes that clear at all. I think it makes it very confusing as to what you're supposed to be disclosing publicly and what your obligations are related to that. All right, so one more slide here on disclosures. So this one is kind of a something's not included, but it's important to note that it's not included. So I just talked about the public disclosure requirement and the proposed changes to that. Interestingly, the department has not put any proposal forward around those individual direct disclosures. So just as a reminder, or if you're not as familiar with the current requirements, under current requirements, institutions must publicly disclose if your program meets or doesn't meet, or if you've not determined if it meets the educational requirements in all 59 US states and territories. Under current requirements for direct disclosures, it has to be done to prospective students prior to enrollment in the program. If it's a does not meet or a no determination made state or territory. And then for your current students, if a state or territory moves into a does not meet category for whatever reason, maybe the state changed its requirements or your program changed its curriculum, or the student has moved to a new location and now they're in a does not meet state or territory, you have 14 calendar days to make that direct notification, that direct disclosure to the student that it's a does not meet state. So that's all, again, existing, what's applicable today for institutions to be complying with. Under this proposal, the department has not changed any of that language. So practically what's happening is we have this disconnect between the direct disclosures and between the new PPA certification requirement and potentially even the new or revised public disclosure requirement. So first, just, student location, again, coming back to that. So there's some different language between this current direct individual disclosure and what the department has proposed under that PPA certification. So this is the same language that I had presented on an earlier slide, but essentially in the disclosure, it's prior to the student's enrollment, and in the proposed PPA certification requirement, it is determined at the time of initial enrollment. So could be a significant difference, it may not. Don't know at this point. I think the bigger disconnect that I see is around the not determined or does not meet states, right? So under the new proposed PPA certification requirement, an institution would only be allowed to enroll students in their Title IV participating programs if it's a state where it meets the educational prerequisites for a license. So how could you have a scenario where you're sending a direct disclosure to a prospective student for a does not meet state if you can only enroll students in a meets state? So I see this as a really big disconnect. And I'm not sure that the department knows or understands that this is here and is a disconnect, even though it was something that was highlighted during negotiated rulemaking, again, very, very briefly in that final session there. So I'm going to leave this for here, but we can always come back to your questions if you have those about the existing requirements and what these proposals are going to change potentially. So let's talk about some of those potential impacts to your institution if this proposal were to go through as is. So some of you are probably already thinking these yourself, or you were thinking that when you initially saw this come out last month. I really do see that this could significantly limit students' choices of programs and the expansion of distance learning for some of your institutions. So because, again, I know I've said this several times, I'll say it again, because this proposed PPA certification requirement limits the institution's ability to enroll for only those states or territories where your program meets or satisfies those educational prerequisites. It means that you're going to have some states or territories where some of your licensure programs will not meet the requirements, and therefore you will not be able to enroll students who are located in those states or territories. So I do think that this will impact some of your institutions, probably even in a significant way right off the bat. If you have students, taking advantage of your distance learning opportunities, and they happen to be located in a state where your program doesn't fulfill all of those educational prerequisites, we know that students are highly mobile now, so they could be well aware that it doesn't fulfill, but they're not planning to try to be licensed in the state where they're located currently. They could be military affiliated. There are lots of scenarios where a student could be currently enrolled in a program that doesn't meet the requirements. Something that is not clear is how current students will be impacted if they're located in one of these does not meet states. So it's not in the proposed regulations. The department, I don't think, has made it clear in any other way how this would be applied to current students. So we could have, a significant impact on those already enrolled in the programs, not to mention a potential, loss of enrollment for those prospective students located in those does not meet locations. Some other impacts and opportunities that I see in this proposed regulation, there probably will be a need for increased faculty and staff to help support this work. So just thinking about the amount of time and effort and work that goes into complying with those existing public and individual direct disclosures, now we're going to have potentially this, heightened responsibility around the PPA certification, where an institution has to determine that you satisfy those educational prerequisites. It may involve trying to get evidence from a licensing board or authority that your program does satisfy those educational prerequisites. All of that's going to take additional time and effort. And we know that many institutions we work with, are already struggling really to comply with the existing disclosure requirements. So adding this new heightened responsibility will require likely an investment in some additional staff or faculty to help support this work, or potentially contracting with an external source to help support it. Maybe that's a positive for you and your team, to get some more folks to help with this work. But I also know the reality of budgets for institutions of higher education right now. I don't know of very many that have funding available to quickly hire additional staff to support this type of work. Other impacts are some additional risks to institutions potentially. So again, this new PPA certification requirement that's proposed is really a higher bar. So we're not just talking about disclosing anymore, but we're talking about the institution certifying through the PPA that your programs do meet those educational prerequisites. So because this is kind of a higher bar, and again, we aren't really clear about what, if any, kind of evidence would be needed from external agencies, we could get into the scenario where the Department of Ed is expecting, a certain review process or a certain type of evidence that an institution needs, and institutions may not be able to meet that bar, or may not be able to secure that evidence, either because the licensing boards won't provide it or can't provide it, or the institution, again, just doesn't have the capacity to be engaging in all of this work that's required to get that evidence or to make those determinations. So the risk, if it's not obvious, the risk is that an institution would not be eligible to participate in the Title IV program for those licensure related programs anymore, which is a pretty significant risk there. Another risk that I see is, currently institutions can use that not determined or no determination made option as far as those public disclosures and individual direct disclosures. And generally it's easier to say something is unknown or not determined rather than make a specific determination. So an institution under these proposed regulations would have to move that to a meets or does not meet determination, potentially for those public disclosures, but certainly for that PPA certification purpose for any state or territory where you have students located or where your institution's located. So having to make that clear decision of a meets or does not meet rather than leaving it in an unknown category is going to involve some more risk to the institution and to your students ultimately who are using this information to help inform their enrollment decisions. Finally, I just wanted to point out an opportunity here for more collaboration between various stakeholders. I have mentioned a couple times that, most licensing boards and agencies don't have a process today where they review or evaluate out-of-state curriculum, to see if it meets the requirements. Today, it really is an individual basis where each graduate from your program applies to that out-of-state licensing board, and then they would review their curriculum, or they would evaluate to see if that program holds a specialized accreditation or some sort of approval from your state licensing board, and they use all of that to evaluate that one graduate's application. So I think there is an opportunity, especially if this proposed language moves forward as is, for state licensing boards and agencies to start collaborating more with out-of-state institutions and others, including specialized accreditors, even state higher education approval offices or agencies, to come up with a process where out-of-state programs could be evaluated against that particular state's educational prerequisites and be put on some kind of list, right? Here are the approved programs that meet our educational prerequisites. Definitely would be a lot more work for those licensing boards and agencies. Again, they're generally under-resourced, understaffed. So something would need to be sorted out here on who's going to help fund this work and make it happen. But I do think there's a potential opportunity for more collaboration there. All right, speaking of opportunities, so I have put together a couple slides here on opportunities for institutions to influence these proposed regulations. First, just wanted to point out the timeline. So much of this timeline happened in the past where they first put forward their public notice to engage in negotiated rulemaking. That negotiated rulemaking took place during 3 sessions last year. There was no consensus reached on this particular topic area, which is why we now have the Department of Education proposing their own language to be part of the regulations on this. And so they published that in May and had a public comment window of about a month, which just closed on June 20th. I'm hoping some of you on the call today were able to submit public comments related to this area and the many other important topics that were part of this package. So I did take a look. There were almost 4,000 total comments received. Again, this is not just about licensure, but this is the total number of comments. It includes gainful employment as one of the issue areas, among a number of other very important topics. So 4,000 total comments received, which is just a tremendous amount. It looks like about 10% of those addressed licensure in some fashion, but only a small percentage of that 10 were really specifically commenting on this new PPA certification requirement related to professional licensure, or the changes to the existing disclosure requirements. So small fraction here, but again, I hope some of you were able to get your comments in about this. Next steps is Department of Education does need to review and consider all of those public comments that were submitted. Again, 4,000 total comments, so a tremendous amount to review here. Depending on potential changes and other factors, there could be an additional Office of Management and Budget review needed, which again would take time if that's required. And just a note then on the timing. So if these regulations are finalized and published in their final form by November 1st of this year, then they would be effective July 1 of 2024. If it happens after that November 1st date, obviously would not hit the July 1, 2024 effective date, and we'd be moved out another calendar year. So as I mentioned, public comments just closed on June 20th. You can see all of the public comments that were submitted on the regulations.gov website. So you all should have access to this presentation. Feel free to use that link and go take a look if you want. You can search in there. It has some limited search functionality if you wanted to try to pull out some particular comments on different areas. Other opportunities to influence potentially. So, Department of Education is the one proposing these regulations. They have the authority to finalize the regulations. However, sometimes there are other players involved that can help influence this. So it's possible that your institution or your university system may have government affairs staff on staff or contracted with outside of your institution that you work with, may want to engage in some conversations with your elected officials around this. Other kinds of associations or organizations, NACUSI, which is the National Association for those independent colleges and universities, possibly their government affairs or related staff would be interested in trying to get the impacts of this out to elected officials and others who could potentially help influence the department's decision on this. And then finally, wanted to point out, media attention. So there was one article I know of that specifically addressed the PPA certification requirement that's being proposed, as well as those changes to disclosures. I have a link there to the Inside Higher Ed article that touched on it. But otherwise, there really hasn't been talk about this in the various articles that came out. So because this is part of a bigger package that includes gainful employment and other very important issues like the state authorization that I mentioned before, those other issues have really gotten the media attention, and this licensure issue has kind of been lost. So there's an opportunity if there are additional media outlets that want to pick this up and try to get it out there. Any information that is made available in general, I think probably makes it back to the Department of Education in one way or another on what the impacts of this are for institutions. All right, so I have just a few more slides and then we will have plenty of time for questions here. But I did want to put together some thoughts on how your institution can prepare for these potential changes, right? So again, just to reiterate, we don't know that these will be the final version of the regulation. Even if this is the final version, we don't know how the department's going to interpret some of this language that they've put out. So there are a lot of variables at play here still. But nonetheless, there are things you can do today to start preparing so that you can be ready for whatever may come out in the future related to a heightened licensure responsibility. So first thing, if you haven't done this lately, is to confirm your institution's list of licensure-related programs. So current regulation says it's any program that is designed to lead to a professional license or certification or advertised as leading to that, or to a career even that would require that. You have to be mindful of those kind of licensure adjacent claims that some of your programs may be making. So make sure that you've reviewed that list and you have a good understanding of which one of your programs are licensure related. It is important to do that periodically because there are new licensure types that are being developed really any day. A state could write into their law a new license type. So there's some emerging professions and careers that are starting to be licensed. So it's important to kind of reevaluate and update those lists as needed. Again, if you haven't already, I encourage you to create your kind of master calendar for when you're going to be reviewing those educational requirements for the other 58 states and territories where your institution is not located, as well as your own. And when that program comparison work will happen. So again, I know that institutions are at various stages of how engaged they are in this work and who is doing this work, but really having some sort of master plan and calendar where it's clear, these are the dates that we will be updating our public disclosures on our website, and then working backwards from there so that there's time for your subject matter experts to compare your curriculum to those state-specific requirements where needed, and that there's time to engage in updating that research as needed throughout the year. One thing potentially for this new PPA certification requirement, I do think it's important to know when your institution will next be going through that review cycle for your Title IV eligibility, because again, it could be up to 6-year kind of cycle here, and each of your institutions will be on a different calendar and date for that. So knowing when your institution will next need to sign the PPA for recertification of Title IV eligibility will be a really important date to help develop your own calendar there. I already mentioned the importance of a plan. So if you don't already kind of have a master plan that encompasses all of your licensure related programs, I encourage you to get one down on paper in some format where you know who is going to do the research work that's required for those 59 states and territories educational requirements, who is going to help compare the curriculum where that's needed. Sometimes it's a very detailed comparison, even down to an assignment level. Often it's not that detailed, but you may need someone who's familiar with the curriculum to make sure you have a certain number of credits, for a particular content area. And it kind of runs the gamut in between there of how detailed that work can be. Baby steps with that, right? So I have a note here. Definitely makes sense to me to start with the states and territories where you have current students enrolled. So again, it's not clear how this new PPA certification requirement may impact your current students, but definitely would be a good idea to understand if your program meets those educational prerequisites everywhere that you have a current student enrolled, right? So start with those states and territories, then kind of work your way out from there. So if you have states or territories where you're likely to get prospective students, those should be next on the list, and then can fill out the rest of the 59 from that point. And then kind of final thought on how to prepare. So I think keeping all of this organized could be a challenge. I know it could be for me at least, definitely. So probably makes sense to have a centralized place, if you don't already, where you can store all this information. So the research that's being done to find and understand those educational prerequisites across the 59 states and territories, the comparison work that's being done by your subject matter experts. So again, if it's one of those very detailed scenarios where they have to look at the state's specific course content areas they want and match up your curriculum, make sure that you have documentation of that and that it's ready. And I say all of this because potentially, if this new change goes through, or even existing for those existing disclosure requirements, theoretically an institution could be asked to provide evidence of how are you making that determination, right? So how do you know that your program meets the educational requirements or does not meet the educational requirements? Being able to go to one place and know that you have documentation there that can help support that determination will be very helpful in the future. People that need to know about this. So definitely your financial aid team, especially those that are involved with the PPA itself, right? So you probably have a person or more than one person at your institution who knows all the ins and outs of the PPA because that is part of their day-to-day job. Definitely make sure they know about this new proposed requirement because it could change some of their processes. And at a minimum, you would need to make sure that there is a confirmation that your programs satisfy those educational prerequisites before they actually sign the PPA. So make sure that your financial aid team is looped in on this and knows what's going on. I also think it's important that your academic leaders understand what this proposal is and what the potential impacts could be to your institution, including that ultimate impact of not being able to enroll students, from certain states or territories where your program does not meet the educational prerequisites. So that could be a big impact. Make sure they know about that and the importance, and make sure that the academic leaders of your institution are supporting the people that need to do this work. So I mentioned it a couple times, but actually engaging in that research to understand what those educational prerequisites are, and then making that comparison to the curriculum, that all takes a significant amount of time. And we know that at most institutions, it falls on the faculty, in particular to do that comparison piece and making sure that your faculty or subject matter experts have the time and bandwidth required to engage in this work is important. And then finally, think about how and when to let your IT department know what's going on. So again, depending on how these proposed changes go through, but potentially related to the existing requirements, if you haven't already fully figured out that direct disclosure piece or capturing a student's location when they change, it's really important to include your IT department so that you can work together to really create a system that's going to be sustainable for your institution on how to identify prospective students and students' location, how to get the right information, the right disclosures out to them when needed. And then in particular, with the PPA certification requirement, again, you may need to limit enrollment for certain states and territories, depending on your programs and how they meet or don't meet those requirements. Kind of final thoughts here, and then we'll turn it over to questions, but on location policy in particular. So I referenced location policy earlier on in a couple of slides. If you don't have, or if you're not sure if your institution has a formal policy in place related to determining location for the purposes of licensure disclosure, I highly encourage you to get on that like as soon as possible, because this location policy, it really will be the key under the new proposed PPA certification requirement, right? So wherever the institution determines that that prospective student is located, that is where the educational prerequisites have to be met. So there are a lot of factors that would go into crafting your location policy or updating it. And it really is going to vary depending on your particular institution's circumstances and the nature of your student population and a lot of other variables. But I have some things here to consider up on the screen when you are working to develop your location policy or to refresh it in light of these proposed changes if they do go through. Just real quick, wanted to point out that Higher Education Licensure Pros does work with institutions to support this work. So again, we formed mostly to help with those smaller to mid-sized institutions that really didn't have any capacity or bandwidth to engage in research or to do that comparison work. So we've been working for the past few years. We actually just launched an online database of education requirements for licensure. We have almost 60 license types now, and it does include those educational requirements or prerequisites for all 59 US states and territories. So if you're interested in that, please check us out, and happy to answer any questions about that as well. But I'm happy to turn it over. I think Leah's going to help us here with some of the Q&A.
Yes, we have quite a few questions, and I will start on first come, first serve. So the first question is, do we know or can we guess if the initial enrollment refers to enrollment into the institution as a whole or specifically into the licensure program? And is it something that the institution can decide?
That's a great question. I am not aware of anything in the proposed regulation that makes that clear if it's initial enrollment to the institution or to the program. I will say, kind of thinking about the intent though, and what the department seems to be pointing at, it would make sense to me, again, this is just me thinking what makes sense, that it's for the licensure program itself, right? So this PPA certification requirement, as well as the disclosures, it's all related back to a program that prepares the student for licensure or certification. So because it's connected to the program, I would imagine that it would be leaning that way. But again, it's not clear, so it could fall the other direction. I'm hoping that the department at a minimum provides some clarifying direction when they release these final regulations, or provide some kind of guidance document after the fact.
Yes, I saw a question. I'm going to bounce around and just answer this question myself about whether the department is considering the kind of financial cost to institutions in doing this. And I can confidently say no. I don't think those outside of higher ed completely understand the logistical issue of knowing professional licensure requirements in every state. So yeah, that the cost is significant, and I think that's one question that will hang around. Okay, so the next question is around teaching licensure. And this is a question about students taking the program in Missouri but live across the border in Kansas. And I assume that that just means that they have to know that in Kansas they can be licensed, but isn't teaching licensure a whole another bucket?
Yeah, so couple of thoughts here. I would say teaching licensure tends to raise more questions or be a little more complicated than some other license types. But even with all that, it still is possible for institutions to make these determinations if their program meets or doesn't meet in other states or territories. For the scenario where we're talking a border situation, it's going to come down to where is your institution located and where is that student located, right? So this is left up to institutions to create your own location policy that's being applied consistently across your students. I would imagine that a lot of institutions would have the location policy set up in that scenario so that your students were located in Kansas, if that's where they reside, and where there are other factors pointing to location and your institutions in Missouri. So you would need to know that your program fulfills those educational prerequisites in Kansas. And as long as you could say, yes, we do, then you would certify through the PPA that, we satisfy those educational prerequisites, and those students would be eligible for Title IV for that.
And related, there are a couple of questions about whether you can enroll a student enrolls anyway after you've informed them that the licensure requirements do not meet the student's needs where they live. What happens if a student enrolls anyway?
Yeah, that's a great question. So under the proposed regulations from the department, again, this PPA certification requirement, it's really on the institution to certify that your program satisfies those educational prerequisites where the student is located. So at the time of initial enrollment, that's important. I should keep saying that too. So if that student, if they're located in a state where you've determined you do not meet the requirements, I see a heightened responsibility on the institution to prevent that enrollment from happening. And if you don't prevent it and someone enrolls anyway, I think ultimately, that student would not be eligible for Title IV. And if an institution does provide access to Title IV, that could be a violation. I'm not going to pretend to know all the parameters around violating Title IV and what could happen, but I imagine it would not be good for the institution or definitely for the student if that happened.
Thank you. Several questions about how states will be monitoring or be able to monitor all of the states and territories required. There are lots of questions about, yes, how to monitor all of that.
Can I clarify, Leah, for our institutions to monitor and keep track of all of that, or for
yes,
a state
for institutions,
entity?
for the institutions, one question asked if they can use the Association for State and Provincial Psychology Boards as the reference, authoritative reference, but also just generally what resource, or is there a resource for states and institutions to be able to find this information?
Yeah, so I will say that as far as I know, there is not a comprehensive resource for any profession that's going to give an institution all of the details they need to know to make that determination, with maybe the exception of ours. And I hate to be self-serving, but We did create our online database, the Bookmark, for that particular purpose. But there are some really helpful resources like the AASPB's National Council for State Board of Nursing, the Association for Social Work Boards. There are various organizations or associations for pretty much every profession that have some amount of information about educational requirements for licensure available through their website. Some of them you have to pay a small fee or be a member to access. But again, typically those do not have all of the detail an institution needs to make that meets or does not meet determination. So if you're trying to figure out your actual plan for your institution, how are we going to do this work? I would say our recommendation is always to have more than one person if you can, because it's a tremendous amount of work. So you have your team in place where you're actually digging into the state's law. So licensure is, different state by state. It's governed at the state level. And so you would want to look at that particular license types, statutes and regulations, look at the licensing board information. Sometimes they make their application materials publicly available, which can shed light on what those educational requirements are. And then utilize those third-party sources like the National Council for State Board of Nursing or others to kind of help supplement and check what you've found yourself in the law and regulation and on the board's website. And then it's compiling all of that into what that full picture of the educational requirements are. And in some instances, it will need a very detailed comparison to your courses in the program. And that's where your faculty or other subject matter experts really need to be involved so that you're sure that, yes, we have a 60 semester credit program that's a master's degree in mental health counseling, but we have to demonstrate we have, X number of credits in each of these different content areas. So lining those up is also a tremendous amount of work at times. And so it's important to have a team in place if you can. I know that's not always possible, but definitely the most useful if you can.
We also have a number of questions about changes that happen. So educational requirements, licensure requirements, students moving from A to B during their education, all of those changes. One question was, will they have to specify the date in which the programs match with states and territories were verified? But also how institutions and states can keep up with the changes. I don't know that that's necessarily an easy answer.
Yeah, those questions are spot on, right? This stuff can and does change with somewhat frequency, depending on which license type we're talking about or which states and territories. So I'd say my first thought is just remember for this new proposed PPA certification requirement that it will be a key date will be when your institution is signing the PPA, right? So if that's going to be happening at some point in the next couple of years, definitely will need to have a research plan in place so that you're able to make those meets or does not meet determinations before the PPA gets signed. But even beyond that, this is something that institutions, in my opinion, won't be able just to sit on for 6 years, right? So if your PPA cycle is 6 years, I don't think it's going to be responsible or prudent to make a determination about meets or doesn't meet and then just wait 6 years until your next PPA. So it will need to be something that's kept up with on a more regular basis. Some ideas on how to keep up with that. So, there are various kind of software products that can be purchased that help monitor legislative changes or regulatory changes. I would say there are ways to do that for free, but it involves going out to each state or territory's legislature's website, and signing up for particular alerts around particular key terms or topics. You can sometimes do the same thing for the regulation itself. If you go to that licensing board's website, you could sign up for an alert for that particular license type. Again, that would be pretty labor intensive to piece together all of those kind of alert services. Beyond that, it's it's setting up that cycle for a regular review. So let's say it's an annual review, and you would have that plan in place of a research timeline, and then build in time for your subject matter experts to do the curriculum comparisons. And really, if you sketch that out across your entire university or college for all your licensure programs, that's going to take probably a full year to get through everything and get everyone through the process. So this work could quickly become something that is happening on a continual basis as you're working your way through each of the licensure programs at your institution.
We also have several questions, and these might be more opinion based, but what drove these changes? Why are these changes being suggested by the DOE? And do you think that they might postpone these again and discuss them again in the upcoming negotiated rulemaking?
Yeah, so first part of that question, there was some commentary that came out with the proposed regulations when they were released last month, that the department indicated that there are students or graduates who have enrolled in licensure related programs and then were not eligible to earn that license after graduating because the program did not fulfill the education requirements. It was very anecdotal, it was very high level. I don't recall hearing any specifics through negotiated rulemaking, during those sessions. I think that the concern is likely being raised by some of the consumer advocate groups who really, they are hearing from individual students or graduates about their experiences, and then kind of framing it in this broader concern or effort that the department has really kind of keyed in on and has now included in this proposed regulation package. So where it's coming from, protecting students, that's kind of the short answer. As far as will this be delayed, it's possible that it will be. I mean, thinking back to, again, this is a very big package of proposed regulations that came out, including gainful employment, state authorization, a lot of other things. There were over 4,000 or close to 4,000 comments on it. The department's going to have a lot to consider with all of those comments, and it's possible that they may decide to push some of these issues back into a negotiated rulemaking. There's definitely precedent for that. We've seen different issues kind of go through the process and get close to final, and then the department announces we're going to do another round of negotiated rulemaking. So possible that could happen for these licensure related proposals.
All right. A question on whether, when you say programs, are you speaking of all 2- and 4-year program students? This person has a team of healthcare programs that are accredited by specialized bodies, which students must pass nationally recognized registries in order to gain employment. Upon passing, the former student is able to work across the country. So will this be impacted by the proposed PPA?
Yeah, so I'll try to answer that. I think it's kind of a couple parts to that question there, but first, so in general, this does apply to any Title IV eligible program at your institution, regardless of degree level or if it's a certificate or something that's not a full degree. If it's Title IV eligible, it would be covered. And it, by the way, is covered today under the current public disclosure and direct disclosure requirements related to licensure. So that's kind of the first piece is, yes, it applies to any level, any type of degree or certificate or program related to licensure that's Title IV eligible. Second part, so I don't think I know enough about that exact scenario, but I will say this because it sounds like this is related to the question here. This applies to state or territory issued licenses, which are also maybe called certification or certificate or endorsement. There's a lot of terms here, which makes this all that much more confusing. I've been saying licensure, that's kind of how the Department of Education frames it. but it's really about that state or territory issued legal authority to engage in that profession or occupation in that state or territory. So it sounds like maybe this question is related to a private issued certification. They mentioned national certification, which is what leads me to believe that. This regulation does not include those private entity issued certifications or certificates. So like, as an example, there's a certification to be a dietitian that's issued by an organization that is full and governs dietitians, right? So that kind of professional certification does not fall under this regulation. This is only about those state or territory issued and required licenses, certification, certificates, whatever it's called.
Okay, thank you. So this person appreciates the preparedness recommendations you provided for institutions, but they say, oh my, how do we as regulators prepare?
Great question, because I do think regulators are going to potentially be inundated with emails and phone calls, and requests for how do we confirm that our program meets education requirements. Even if you're working for a state office of higher education, I think you probably will maybe be fielding some of these questions and calls as well, in hopes of trying to connect with the state boards or agencies that actually do the licensing. I think the best way for an office of higher education to help prepare is just make sure that your institutions know about this and that they know about the current disclosure requirements. So if institutions aren't, fully there yet with the public disclosures and those direct individual disclosures that are required today, it's going to make it that much more overwhelming to try to comply with this proposed new PPA certification requirement. So helping everyone get up to speed as quickly as possible and be in compliance, making those determinations, if their program meets or doesn't meet for the other states and territories, in particular where their students are located now. That's all going to help ease some of this potential burden that will come with a new PPA certification requirement if it comes to be.
Okay, you're doing great at answering these questions, Chris. Do you need a moment to take a drink or anything? Oh, there you are.
I'm just going to do it.
All right, so what happens if an institution makes an attempt or several to contact a licensing agency, but they receive no response? Do they just not offer their programs in that particular state?
So I think the answer to this question is ultimately going to be an institution by institution decision. And before an institution makes that decision, one big unknown is what, if any, evidence will the Department of Education be expecting institutions to have at the ready around making these determinations? So just a couple of my thoughts on this, right? Let's say that the Department of Education does expect institutions to have this kind of approval letter or some sort of email that's affirming, yes, your program satisfies our educational prerequisites, which again, side note, it's going to be very, very challenging to get, and maybe impossible in some places, at least as of today. But let's just say that's the department's expectations. If an institution is making that, real effort to get that documentation, that approval, whatever it is, and it's simply not possible to get because of that state or territory's processes, but they've done their own internal comparison and believe that the educational prerequisites are met, an institution may decide that we can offer the program. We've done our due diligence. We've reached out to this licensing board multiple times. We're not able to get something in writing from them, but all signs point to yes, it works. Our curriculum matches up. Maybe they've had some graduates get licensed in that state in the past. An institution may decide that they're able to do it. there's nothing in the proposed regulation that says you must have, this approval email or this, official document from a licensing board. So unless the department is very clear that that absolutely is required, I think many institutions would be comfortable continuing to enroll people if those other factors fall into place. But again, this will be an institution by institution decision. And something that you'll have to work through with your legal counsel and others to decide kind of where the line is going to be for your institution. Some may say we're not comfortable unless we can get that written confirmation from the board. And then you would choose not to enroll students from that particular state or territory. And I kind of say that like a little bit forlorn because it's really sad to me that, again, the ultimate impact on this is going to be most likely limiting students' choice of which programs and institutions they can enroll in. And it could be for a very unnecessary reason, right? If they actually could meet the requirements or they don't even want to get licensed in that state anyway, they're planning to move or they're not planning to get licensed. So I digress, but.
What about programs that require multiple degrees for you to be licensed? An example, in engineering or in architecture where, the bachelor's degree isn't actually enough to meet the licensure requirements. Do you have to guarantee each level, or is it the terminal degree that leads to licensure, the one that you need to focus on?
Yeah, this is a great question. And again, something that is not clear or covered in the current regulations for disclosure or the proposed regulations that the department's put forth. What I tend to fall back on and encourage institutions to really think about is, what is your program designed or advertised for? So that notion and that language is in current regulation. It is similar in the proposed regulation of defining what a licensure program is. What is it designed or advertised for? And I know that this can get pretty complicated with those tiers or levels of degrees that are required. I gave the example for accounting earlier, which is similar to that. For CPAs, you typically go through a bachelor's program in accounting, but that in of itself is not enough to meet the licensing requirements. You need credits beyond that, either through a master's program or some other type of certificate or some other thing. So again, think about how are you advertising it? What's the program designed for? Once you're clear on that, then I think it should become pretty clear on if you can say you meet or don't meet in a state or territory. So we've worked with some institutions on the accounting example I just gave fairly recently. And if our guidance or our suggestion was, as long as you're clear in your disclosure about you don't meet at the bachelor's level, but you could put a note with that does not meet because every state requires 150 semester credits. Our program's 120. I think you would be giving your prospective students the right kind of information through those disclosures, right? So you're clear that our 120 credit bachelor's program in accounting does not meet the requirements, but in combination with our master's program or in combination with other credits, you could fulfill the requirement. That would be the scenario if you're really advertising that bachelor's program to lead to the CPA. You may want to decide that you don't advertise the program that way anymore, right? So it's not designed for licensure because it's not 150 credits. And if you're not advertising it as this is going to help you get the CPA, then maybe that program's not on your licensure list anymore. Again, it's going to depend on kind of how your institution thinks about your program, runs your program, advertises your program. But those are some possibilities. And I'm kind of not answering, I think, the big question of what's going to happen under this proposed new PPA certification requirement for a program like that. It's not clear. I mean, I don't know. I think institutions could probably come down on both sides of that, again, depending on how they end up framing that program. Is it a licensure program? Is that engineering program at the undergraduate level is it really designed for licensure in engineering? Is that accounting program really designed for that? And there's different ways to think about it.
And I know your helpful timeline slide provided a lot of information. I think people are wanting clarification on whether you think July 1, 2024 will be the date where they have to have everything ready to go.
So kind of question of like, would there be some sort of extra time given? If the effective date of the regulation is July 1, does that really mean everything's got to be ready to go July 1? I don't know. I know I've said that lots today, but I will say this. So with the existing regulations around public disclosure and direct disclosure, there was no kind of, grandparent, grandfather timeframe. There was no extra timeframe given. So when that regulation was effective, July 1 of 2020, everything was effective July 1, 2020. So there was not additional time given. Maybe the department would do that this time. We don't see that in the proposed regulations now. There's nothing in the proposed language that says, here's what's required, and institutions have, 2 extra years or 3 extra years to comply. That language isn't there now. So I guess I would be kind of surprised, but it's certainly possible, especially if they receive some written comments about what the impact of this is going to be and the amount of work required. They may be willing to slide in some additional time for institutions to get ready.
Okay, so the National State Boards of Nursing is working on a SARA-like reciprocity for nursing licenses. Do you know of any other organizations working on streamlining state licensing board requirements for licensure programs?
Yeah, so I actually do know there's an effort underway for teachers as well, a new compact. And we see compacts that are either kind of currently under development or that have recently been developed that states are adopting. Counselors is another one that's relatively new and was officially adopted and enacted just within the past year. So I think all of these efforts around compacts are definitely great for our licensed professionals, for our graduates. I think one challenge is that because a profession has a licensing compact where they're facilitating that, more easy transfer of licensing, if you will, from one state to another, or the authority or ability to work in another state or territory, it doesn't really help us with this problem. And the reason why I say that is the department's regulation is focused on, does your program meet those educational prerequisites for a license in that state? And typically, these sort of compact or reciprocity agreements are for people who already hold a license and want to move to another state or territory or work in another state or territory. So because it's about a licensed person and not a graduate applying for that first license, typically, these compacts aren't really factored in or helpful in making these determinations if your program meets or doesn't meet the educational prerequisites for that initial license.
We have a couple of questions about the consequences or penalties for not complying, or if a school or an institution was wrong about the student's eligibility for licensure.
Yeah, so I know I said it before, I won't pretend to be an expert on the Title IV program or penalties around that, or really anything financially. That's not my background or expertise. But I will say it is clear, this proposed PPA certification requirement would be along the lines of anything else that's contained in the PPA today. All of those particular terms and conditions and things that institutions need to ensure they're doing or not doing to continue participating in Title IV. So I would imagine that penalties would look similar to other violations that an institution might have today around, not fulfilling those obligations or terms under the PPA certification, which ultimately, the ultimate penalty is an institution would no longer be allowed to participate in Title IV. And there's obviously many steps along the way of what would happen before then, in terms of probation or, different kind of remediation steps that an institution would need to go through. I think you asked me a second part of that question, Leah, that I lost if you did.
Well, let's see if I can find it. I think it was just mostly, do we know if there are penalties? Whoever asked those questions, if we did not answer it fully, please add that to the Q&A. As a reminder, as we're getting to the end of this, any questions that were not answered during this will be answered later and posted with the post webinar materials. And we also will provide documents for the resources that Chris has mentioned that will be helpful for doing some of this work. I know, Chris, a lot of this is still hypothetical. We don't know a lot, and the department has not clarified a lot. So there's not a whole lot in terms of the specifics that we can answer at this point. You think that's correct?
Yeah, again, my goal for today was to make you all aware of what the department's proposed language is, some of those potential impacts, and maybe help you start thinking about things you could be doing today to prepare if this does come to fruition in its current form, or just, to help you shore up your existing compliance processes around the current public disclosure and direct disclosure requirements. So
I think you've covered the basics of most of the questions that are left. If there are very specific questions, we will answer those post webinar. Any final thoughts from you, Chris or Nan?
I just want to thank you all for spending some time listening to this and thinking about this topic today, this afternoon. Again, I know that there are a lot of things going on with Department of Education proposed changes that will also have very big impacts on your institution. But this licensure piece could also be a big impact. And, a lot of folks aren't really hearing about it or thinking about it as much. So thank you for taking the time and for your great questions today. I appreciate it.
Thank you, Chris and Leah. I've just been looking for resources that I'll help promote with Leah and Matt afterwards.
Yes, we will be as helpful as we can be in this time of hecticness. Well, if that is all, I think we are 3 minutes early, which is not bad.
Take care, everyone.
Have a good day.